You will never apply for this job. There is no application, no interview, no test. The 9 most powerful legal positions in the country. Positions held for life. Reviewable by no one. Reversible by nothing short of a constitutional amendment. Have no hiring process. Here is the number that should stop you cold. Since 1789, 115 people have held a seat on the Supreme Court. In that same span of time, the United States has produced over 1 million licensed attorneys. 115. Out of 1 million. And the part that nobody tells you, the part that makes this climb genuinely strange, is that most of the 115 did not set out to get there. They set out to be the best lawyer in the room. And then one day, someone called. Level 1. The 1L. You are 23 years old. You went to a school with a name that made people go quiet when you said it. You finished near the top. You wrote a thesis. You have 3 letters of recommendation that border on embarrassing. You walk into your first class and realize, within 11 minutes, that everyone in this room has the same file. The professor is using the Socratic method. He asks a question. The student answers. He asks a harder question. The student answers slower. He keeps going until the student either says something genuinely sharp or runs out of ground. This is not cruelty. This is the first filter. He calls your name. You have 180 classmates. By the end of this year, roughly 18 of them will finish in the top 10%. Those 18 will be positioned to clerk for federal judges who matter. The other 162 will become excellent lawyers. Some will become partners, prosecutors, professors. A few will make more money than the justices they once dreamed of becoming. But they will not be on the list. Because this climb doesn't care about good. It only has room for the specific. You came here thinking you'd finally found your people. You have. That's exactly the problem. By December you've read 600 pages of case law. You've lost 7 pounds. You stopped calling home as often because explaining why takes longer than the call. Your Casio reads 2 a.m. most nights and you've stopped finding that notable. At the end of your first year, your grade comes back. You look at the number. Then you look at the rank next to it. Everything from here depends on that rank. Not the grade, the rank. And here's what that rank actually means. It's not an assessment of how well you learned the law. It's a signal, to judges, that you survived the room. The professor who called on you that first day. He clerked for a circuit judge 20 years ago. You are going to need someone exactly like him to write your letter. That's level 1. Level 2, the clerk. You are 26 years old. There are about 2,000 federal clerkships in the country each year. Most are invisible to the path you're on. What you need is a circuit court clerkship. And not just any circuit. There are 13 federal circuits. The one that matters most is the D.C. Circuit. 11 judges, 11 offices, 11 desks where, over the past 40 years, a disproportionate share of eventual Supreme Court justices once sat and wrote memos that no one outside the building will ever read. You are sitting at one of those desks now. Your job is to read briefs and write bench memos. Summaries of cases the judge will hear. Arguments on both sides. Your recommendation. The judge will read your work. Sometimes she will use it almost verbatim in a published opinion under her name. You will not be credited. That is the arrangement. That is how this has always worked. At 11:40 p.m. on a Wednesday in March, the judge walks past your desk and sets down a 94-page brief without stopping. She says, "Tomorrow morning." That's it, no other instruction. You don't ask what time. You don't ask what she wants. You have been here long enough to know that tomorrow morning means it's on her desk before she arrives. She arrives at 7:15 a.m. You will finish the memo at 6:48 a.m. It will be the best 17 pages you've ever written. She will read it in 11 minutes and circle one sentence. That nod is the entire performance review of your year. Now here is what you need to understand about what happens next. Because this is the part almost no one explains clearly. There are 36 Supreme Court clerks selected each year. 4 per justice, 9 justices. You do not apply to the court directly. You apply to individual justices. And each justice pulls almost exclusively from a set of specific circuit court judges they trust. Judges who have been sending them clerks for decades. Judges whose recommendations carry actual weight. Your judge is one of those judges. Which means you are now one step removed from the shortlist. One step. But that step has a name on it that isn't yours yet. That's level 2. Level 3. The career. You are 28, then 38, then 47. Here is the thing about the climb to the Supreme Court. That makes it unlike every other ladder on this channel. On Wall Street, there is a track. 2 years analyst, 2 years associate. Make vice president, make director, make managing director. You can draw the org chart on a napkin. You can calculate your trajectory by year. This track does not exist. There is no Supreme Court org chart. There is no standard promotion timeline. Of the 9 current justices, no 2 took the same path. Some came from government, some from academia, some from private practice. One spent almost no time as a judge before being confirmed. What they share is not a path. What they share is a pattern of being impossible to ignore. Most people who eventually reach the court spend a decade doing one of 3 things. And the smartest ones do pieces of all 3. Government. The Solicitor General's office. You become the lawyer who argues the federal government's cases before the court itself. The justices hear your voice dozens of times before they ever consider your name. That is not an accident. Private practice. Appellate boutiques. You build a practice around federal appeals. You file briefs in cases the court will take. Over time, your name appears in their reading so often it becomes familiar. The bench. Federal judgeship. You write opinions. Some get appealed. Some get reversed by the court. With your name in the opening paragraph of the majority opinion. Even a reversal means they read you. But here is the number that will reorient everything you think you know about this track. The Supreme Court receives roughly 7.000 to 8.000 petitions per year. It takes about 70 out of 8,000. When you write an opinion as a circuit judge, on one side of a legal question that another circuit has decided differently, and the court takes the case to resolve the split, your name is on their desk. Not because you won. Because you wrote something they had to respond to. Most people who lose in the Supreme Court become footnotes. A few become justices. Being reversed by the Supreme Court in a landmark case is a more direct line to the building than winning a case they never notice. You have spent 20 years becoming someone it is difficult to overlook. That is, it turns out, the entire strategy. That's level 3. Level 4. The list. You are 52 years old. You do not know you are on a list. Lists like this are not announced. They are built quietly. By staff inside the White House counsel's office. From names that have been circulating in certain rooms in Washington. For years, sometimes decades. When a justice announces retirement, or dies in office, the counsel's team has usually been preparing for this vacancy for months. The list exists before the vacancy does. Yours has been on it for 2 years. They have read every opinion you've written in 18 years on the bench. Not just the holdings. The reasoning, the footnotes, the dissents. The cases where you ruled against what anyone would expect from your background. Every public statement you have made since law school. They have found the conference panel from 2011. Where you used a word they've now run past 4 different communications consultants. The consultation is not about whether you are qualified. You are unambiguously qualified. This conversation is about one question only. Can you survive the confirmation? Because the Senate Judiciary Committee is 22 senators in a room full of cameras. And your record, every ruling, every word, is about to become opposition research. They will find the 3 decisions you were least proud of and release them in 48-hour cycles timed to the news cycle. Your opponents will characterize your most careful legal reasoning as evidence of something sinister. You will sit in that hearing room for 3 days and answer their questions. Most nominees have spent months practicing their answers. Not the answers to questions they'll be asked. There's no way to predict those. Practicing how to answer every question by saying almost nothing. They call it a murder board. A room full of lawyers who take turns asking you the hardest question they can construct. You answer. They find what's wrong with your answer. You answer again. You do this for 8 weeks. Becoming a Supreme Court justice requires a mind sharp enough to reshape constitutional law for the next generation, and a face calm enough to spend 3 days being called dangerous without blinking. The court requires both. Only one is tested in public. On the 3rd day of your confirmation hearing, a senator asks you a hypothetical so precisely constructed it has no safe answer. You pause for 4 seconds. Then you answer the question he actually asked, not the one he was trying to ask. And the room goes slightly, almost imperceptibly, quiet. Your lawyer, watching from the 2nd row, writes one word on her notepad and underlines it. That's level 4. Level 5, the seat. You are 58 years old. The Senate voted 54 to 46. You are an Associate Justice of the Supreme Court of the United States. You will serve until you decide to retire, or until you cannot. The average tenure for a justice confirmed in the last 30 years is 26 years. You may be deciding cases in your mid-80s. On your first day, you sign your name to a bench memo written by your clerk. Your signature at the bottom. No appeals process above it. No supervising partner. No senator to call. For the first time in 35 years, the pen stops with you. You will spend the next decade reading, asking, arguing, writing. Every word you write is precedent. The cases you decide will be cited by judges who are not yet in law school. Your dissents. The opinions where you are in the minority, where you lose, may matter more than your majorities. Some of the most influential writing in the court's history came from justices who were outvoted. Here is the thing about reaching this seat that no one outside the building understands. You have spent 35 years in a profession that rewards persuasion. Clerk for a judge, impress the partners, win the argument, pass the vetting, survive the hearings. At every rung, you convinced someone of something. Now, no one can remove you. No one can promote you. No one grades this work. Some justices find that clarifying. They spend decades writing exactly what they think, exactly how they want, and the country has to reckon with it. Some find it disorienting, because the discipline of always having someone to answer to. The partners, the senators, the appellate courts. That discipline turned out to be a structural support. Remove it, and some things shift. Of the 115 people who have ever held this seat, fewer than 10% were women when confirmed. Fewer than 5 have been black in the court's entire history. The average age at confirmation is 53. You are in a category so statistically rare it is almost fictional. And yet, the clerk sitting in the outer office. 26 years old, top of her class, first year of her clerkship. She has the same file you had at her age. She does not know yet what she's building. You do. That's the only thing that changes. That's level 5. Somewhere right now, a first-year student is standing in a law school hallway. After getting called on for the first time, her hands are shaking slightly. She doesn't know if this is the beginning of something or if this is just Tuesday. She doesn't know yet what the next 35 years costs to get here. She'll find out the same way every justice on that court found out. One level at a time.